incredibly gracious, allowing us to have access to the Virginia Department of Corrections and the Parole Board. And my team did yeoman's work interviewing over 40 witnesses and reviewing thousands upon thousands of emails. Chairwoman Bennett's parole board emails were all deleted, and she refused to discuss multiple cases and matters during an interview with us. However, we can confirm that Adrienne Bennett's unexplained absence from the bench in the spring of 2021 was because she was suspended by the Judicial Inquiry and Review Commission for some of the actions detailed in this report. To summarize, our investigation revealed that Parole Board Chair Adrienne Bennett violated at least 8 court orders that found offenders ineligible for discretionary parole. These offenses violate Virginia Criminal Code 18.2-456, but they cannot be prosecuted because of the applicable statute of limitations. Our investigation concluded that Chair Bennett falsified 3 parole discharge records for 3 first-degree murderers. These offenses are Class 1 misdemeanors, carrying up to 12 months in jail, and an inability to hold any office of public trust upon conviction. She also cannot be prosecuted because of the application of the statute of limitations. We also noted that after she became a judge, she violated Canon 2N of the Virginia Canons of Virginia Judicial Conduct. Why? Because she continued to transact business of the parole board even after she became a judge. Well, this is an incredibly serious offense because in Virginia, separation of powers is sacrosanct. And even though she was on the bench as a judicial officer, she was still conducting her powers, or attempting to conduct powers, that is reserved for the executive branch. In addition, Chair Bennett committed hundreds of other policy and procedural violations, including procedural violations noted by the very Virginia Parole Board that she chaired. And now we know from the multiple instances of release of prisoners, violent offenders, there are innocent Virginians that have had their lives turned upside down because their attacker, their assailant, the person that held the gun up to the head to a young clerk at a gas station, their lives are turned upside down because their assailant should have been behind bars, and they were released because of the decision of this parole board. I would be remiss if I did not discuss the Nixon Peabody investigation. To refresh everyone's recollection, 2 years ago, the General Assembly gave $250,000 to a New York City law firm, Nixon Peabody, to conduct what turned out to be essentially a whitewash of the original investigation to the parole board by the Office of the Inspector General, giving some that needed help a talking point they needed. It was a campaign year, and it was clear they would rather investigate the Inspector General's office than the fact that violent repeat offenders were being released back in our community and hurting and endangering more innocent Virginians. We examined their report, and we found that they significantly omitted material information that skewed the outcome, denying the public the report. 2 of the people that were the heart of this entire scandal, Chair Bennett and the Inspector General's investigator, Jennifer Machete, were never even interviewed by Nixon Peabody. Contrary to the findings in the Nixon Peabody's report, which they claim the Inspector General's review of the release of Vincent Martin, Nixon Peabody said that somehow that was a biased report. The overwhelming majority of the witnesses interviewed by Nixon Peabody viewed that Jennifer Machete and the OSIG investigation of Vincent Martin was unbiased and professional. Of the 18 witnesses Nixon Peabody interviewed about the Inspector General's bias, 11 of the 18 stated OSIG and Machete were unbiased and professional. Only 5 expressed the belief that the investigation was biased, and 4 of those 5 were Northam administrative appointees. It is simply stunning what failed to make a report that cost taxpayers $250,000. In fact, the Inspector General's legal advisor in the AG's office told Nixon Peabody, quote, "It appeared that the governor's office was putting pressure on OSIG." And furthermore, this person found that OSIG's investigation was, quote, "very independent and thorough." That was not in the report that Nixon Peabody charged the taxpayers of Virginia $250,000. It was not in the report that even Governor Northam's chief of staff, in his interview with Nixon Peabody, criticized Chair Bennett and acknowledged that Chair Bennett should be held accountable for her own actions, and that she showed a lack of common sense and a lack of good judgment. This is what he noted in his interview. That did not make the Nixon Peabody report. I will allow the individuals here to determine whether they should call Nixon Peabody and perhaps ask for a refund for $250,000 of taxpayer funding that went to a report that never even got to the truth. Now, our report also makes several recommendations. Over 20 policy and legislative recommendations to ensure transparency of the parole board actions to restore the confidence and integrity in the criminal justice system. These recommendations include enhanced ethic rules for parole board members, stronger victim notification requirements, increasing the size and public transparency of the parole board, and amending multiple sections of the Virginia Code to better guide the work of the Virginia Parole Board. This investigation's purpose is to make sure that the tragedy that happened never happens again. What happened here was wrong. What happened here was a clear abuse of power. What happened here was the epitome of putting criminals first and victims last. Victims were ignored, laws were broken, and the very most violent offenders in our society were the ones that benefited from these actions. This isn't a partisan issue. People being hurt is not a partisan issue. Victims having their lives upended is not a partisan issue. We often hear about criminal justice reform, and I've always said we must be mindful of those victims that have had their lives upended by simply being at the wrong place at the wrong time. These are real Virginians with their hopes and their dreams and their aspirations. Real Virginians that should not be looking over their shoulder in fear. Their lives are permanently altered and victimized all over again by a parole board that had no regard for their stories, no regard for their rights, no regard for their trauma. Let it never happen again. In conclusion, it is clear that under Chairwoman Adrienne Bennett, the Virginia Parole Board endangered public safety and abused its power by releasing dozens of violent felons against the parole board's policies and frequently in clear violation of Virginia law or a court order. Judge Bennett's brazen abuse of her power put Virginia's safety at risk so that she could promote the criminal first, victim last agenda without regard to the victims or their safety. I want to thank again the hard work of my amazing team for compiling this report. I'll be remiss if I didn't thank you, the members of the media. This was not brought to my attention, as so many other Virginians, until you did your work by breaking this story in the early spring of 2020. I want to thank you for your due diligence and your work in this regard. It is in many ways the very, very best of what democracy is. And I want to thank you for your interest in the story. Now, without further ado, I'll be glad to take it.
Could you elaborate on the statute of limitations piece? I'm a little confused how something that happened less than 3 years ago is already such ancient history.
Even some of these charges that are class 1 misdemeanors, if you're able 12 months in jail, in Virginia, it's a year statute of limitation. So the fact that it wasn't proper due diligence and investigation, that time passed in 2000.
Do you think she should continue serving as a judge in Virginia?
Well, you know, we have a sitting judge that by all counts, by our investigation, violated a variety of different laws and procedures. And by our investigation, included likely falsified public records. And so I will let the General Assembly has to make that decision on whether they are going to choose article of impeachment. That's a decision of the General Assembly, and no longer serve that body. I think the report speaks for itself. Yes, sir.
Through your investigation, were you able to determine how that first draft report went from 15 pages to 6, knowing that in the 15-page report it clearly stated that 2 of the chair people were to be charged with misdemeanors if it went through?
Yeah, I may Theo's remark a little bit on this. Everything we determined is they determined to make the report as narrow as possible. They got it down to 6 pages, which is obviously much lengthier than that. I don't know, Theo, if you want to...
I think that I would say that best characterizes the OSIP report, that they were conservative in their assessments and they just kept it very narrow.
So there was no evidence of someone proofreading the report because it was scathing that Westfall delivered the 15-page draft, and someone at the AG's office at that time, Mike Herring's office, said, "Whoa, we got to get rid of some of this stuff."
No, it was read by a number of individuals. Both the Mike Westfall, his deputy, in-house comments were made by an OAG lawyer at the time. But the goal was to have a conservative, very narrowly drafted report, and most likely because of all of the publicity that was underway at the time.
Last question, real quick. Did Westfall, did he cooperate with this investigation?
Absolutely.
I mean, it was clear to us that at a time when we were expected to maybe be able to ask those hard questions, and I think that there were a time to have more of an expansive review. They tried to make it as narrowly tailored as humanly possible instead of asking a lot of these hard questions. These are questions that could have been answered in 2021. Everything that we detailed could have been discovered and answered and revealed to the public in 2021. And failed to do so.
Were they shoved aside, you think, to help with the statute of limitations, so there couldn't be charges?
That's going to be something that's speculative by nature, but I know this, by the fact that people were asleep at the switch, the statute of limitations expired. And so there's nothing that we could do with that regards. But the reality is these answers could have been found in 2021, and they weren't found, and it was solely and totally because of a lack of will.
I guess another question I have is what do you think taxpayers are going to think of this, looking, saying, okay, basically, no one's going to be held accountable because the statute of limitations expired?
Well, the ball is somewhat in the General Assembly's court as far as Judge Bennett. The ball is in her court in that regards. And I think the reason why we have done this probe work is also to serve as a warning for future probe boards. They say the only thing you learn in history is nobody learns from history. We hope that this report is read diligently by the Governor's Administration, who hand delivered the report by the Virginia Department of Corrections and the new parole board, and the Governor to place them on how not to conduct these reviews of these inmates and whether to release individuals with parole officer supervision. Other questions?
What message do you think this report, what message do you want this report to send to victims and families of those victims of these horrendous crimes moving forward with your plan?
Well, I said before that my role as Attorney General is being the people's protector. And for the victims who often felt marginalized, the victims that felt ignored, the victims that would call the parole board and nobody would return a call, or nobody would consult them, they could find out in the news sometimes. Someone, an individual is quite enormous amount of pain to themselves or their family was released, that I will always have your back, and that I will be your voice.
Did you get a satisfactory level of cooperation from Norfolk administration officials? How many folks, you said Secretary Moran has interviewed with other folks?
No, Secretary Moran was, but I'm not.
He was the only administration official for the Northern Administration that we interviewed. Am I mistaken, Reagan? Oh, the parole board members who were on, yes, they all, and that's all in the reports.
Did you seek to interview any other Northern officials, like the chief of staff or the governor himself?
No.
Ms. Machete was sort of demonized as being the whistleblower in this by the previous administration. Have you spoken with her as far as indication that this report found that they were unbiased in their investigation?
We interviewed Mrs. Benny and she was very cooperative. We have not talked with her since the interview, so I'm sure she'll be grateful to read the assessing her report.
I'm curious about some missing email accounts. So we don't know where those emails went?
We've never gotten a satisfactory answer of what happened.
Could there not be charges for someone deliberately destroying official documents?
Our obstruction of justice statute, criminal statute in Virginia is not as strong as the federal. Let's just put it that way. That's our law.
One more question. Are you able to speak to the outcome of the Jerk Commission's review, which I don't think.
She was suspended, but I can't speak to that. A lot of that is by its nature confidential.
But that wasn't related to her actions on the parole board using unsafe specifically.
Yes.
Awesome. Thank you guys.
All right. Thank you.